Hello, I'm attorney Gloria Allred. On May 15, 2008, we won our case before the California Supreme Court on the issue of same-gender marriage. The court struck down the ban on such marriages as unconstitutional. We represent Robin Tyler and her same-sex life partner Diane Olson, and Reverend Troy Perry and his partner Philip DeBleek. We filed our lawsuit on their behalf against LA County after each couple was denied a marriage license in Beverly Hills on February 12, 2004 because they were of the same sex. We were all thrilled and elated with our tremendous victory in the Supreme Court. Robin and Diane have been looking forward to marrying in Beverly Hills on the first day possible, which is June 16, 2008. However, last Thursday, the opposition, Proposition 22, Legal Defense and Education Funds, filed a petition for rehearing with the California Supreme Court, asking the court for a stay, which is a delay of the implementation of the decision and the marriages, until the voters vote on a constitutional amendment which they hope to have on the ballot in November, in which they seek to ban same-gender marriage once again in California. Today, we filed the first brief, which is an answer, with the California Supreme Court, in which we oppose the request to stop the same-sex marriages from taking place. Our goal is to allow marriage licenses to be issued as planned on June 16, 2008, so that our clients may marry as soon as possible. Robin and Diane have been waiting for many years for the right to legally marry each other in California. We have fought the legal battle for them for more than 4 years in the California courts, resulting in our Supreme Court victory on May 15th. We see no reason for them to be forced to wait any longer for this fundamental right which we have fought for and won. In our brief to the Supreme Court, we emphasized that we oppose any delay in the implementation of the court's decision, and that Prop 22's argument should fail because it boils down to the word might. They, in essence, argue that they might have enough signatures to place their proposed constitutional amendment banning same-gender marriages on the ballot, although sufficient signatures have not yet been certified. They argue that if they have enough signatures, the voters in November might vote to pass it, or might not. We argue in our brief that it might not qualify for the ballot, might not pass if it does, and there might be legal challenges to it if it does qualify for the ballot and/or is passed. In summary, we say that their petition, seeking a hearing on implementation and a stay of the court's decision, is actually premised on a long string of hopes, not hard facts, and should be denied. Also, if the couples are permitted to marry June 16th and thereafter, and the marriage initiative, constitutional amendment, does pass, the courts of our state are perfectly capable of adjusting the consequences, if any, for the individuals who sought same-sex marriage in California, with their eyes open to these possibilities. For many years, same-sex couples have trusted the courts to vindicate their rights. The Supreme Court has deserved their trust by standing for marriage equality in California. We hope that the court will continue their courageous stand by refusing to delay the implementation of their decision. As lawyers, we know that justice delayed is justice denied. Every day that Robin and Diane are unable to marry is a day when they will suffer the personal agony of justice being denied to them, and the irreparable harm that such delay will cause them, emotionally, legally, socially, and in many other ways. Justice for these couples is long overdue. The time for justice is now.